Court does call the case. People versus Herbert Isom.
However, on behalf of Mr. Isom, who is approaching the podium and will be standing to my right. Mr. Isom, once you get up here, please introduce yourself to the court.
Herbert L. Isom.
Thank you, sir.
Today's date and time set for pretrial. We are asking for an adjourned pretrial date. We understand that December 16th is the date that the court's giving.
Well, I will give you a date.
Okay.
How much time do you need?
I just was appointed, whatever the next available date is.
December 16th. I'm not giving him that because he asked.
I was given by the staff, Your Honor.
Why are you giving up date? Okay, I'll let talk about what you do. Nah. No, don't give me the hand. All right. Miss Londa, you have arisen?
The people would like to address following if the court's ready.
Yes. I'll adjourn the matter to December 16th, 2024, 1 p.m. Yes, Esteban.
This is a domestic violence case. In this case, the victim of the domestic violence incident was present in the courtroom. She informed me that the defendant sat down next to her in the courtroom when he came in. They were sitting together. My victim advocate did see that. They were separated when Mr. Lindell took the defendant out and told me to speak to them. And at that time, I know the victim advocate went and spoke with the victim. For the record, this is not a crowded courtroom. There are many, many open seats available. There is a no contact order that was entered on November 25th, 2024. It's now December 2nd, so just a few days ago, where the defendant wants to have absolutely no contact with the victim. People would contend that sitting next to her is contact. I understand that she is here to address the court to request a removal of the no contact order. I have other information about that to share with the court whenever the court's ready, but she hasn't made that request yet, so it may be premature for me to respond to it. But I'm very concerned by him sitting down next to her when he's supposed to have absolutely no contact with her.
Response.
Yes, Your Honor. It is true. I spoke with Mr. Isom and as well as the complainant this morning. It is my understanding that we will be making a request to lift the no contact order and the no go to order. Mr. Isom tells me that he has had no other contact. He has been abiding by the no contact order except for in the court this morning. And it's my understanding that—
Where does he reside?
Where you live at the moment?
My brother's.
Okay, go ahead.
And Your Honor, we are requesting that the no contact order be converted to a no non-consensual contact order, as well as a no go to order be lifted. It's my understanding that the complainant needs help around the house with both for herself as well as for their 4 dogs. And so we are just requesting that I did talk to my client about what the no contact order means, and that at the meantime, he should not be having contact until the court agrees. After we spoke, I instructed him to separate himself and sit on the other side of the courtroom, which he had no issue doing. So no matter what the court orders today, I'm confident that Mr. Isom will abide by whatever the order is, but we are requesting that.
Well, did he understand there was a no contact order in place?
Yes, I understood it, but I didn't know that in the court that would be the same thing. I thought with the people here that—
Why would it change?
I'm stupid. All I can say, ignorance.
What street are you staying on right now?
I'm staying in an apartment with my brother. It's right off of Michigan, or what's the name of the road? I don't even know the name of it.
Is it in Ypsilanti?
It's in Belleville.
Well, I'm going to tell you at this time, sir, the best I can explain this to you, because I've had this other same incident occur just last week. I take the no contact orders very seriously. And when the court says no contact, that means no contact.
I understand.
Ms. Lundy, you wanted to say something else?
Your Honor, I just will let the court know as well. I heard the defendant say a second ago that he was staying off of Michigan. I would note for the record that the address that he shared with the victim was also off of Michigan Ave. So I hope that he is being truthful when he says that that's also where his brother is. We did request a $25,000 surety bond. He was given a $5,000 PR bond, no electronic monitoring. And the defense has moved to change the no contact to no non-consensual contact. I know the court historically has liked to hear from the victim, and if the court intends to follow that procedure, I'm happy to place my concerns about that on the record after we hear from her, or I can do it now, whatever.
No, I can hear from you afterward.
Okay.
Okay, where is she? Come on, sir, have a seat over here. Hello.
Good afternoon, Your Honor. My name is Donna Dennison, and I truly understand about the no contact, and I truly apologize. When he came into the court, I just scooted over so he could sit next to me. I didn't, like he said, ignorance. And I understand and I respect the court, and I duly greatly apologize. But me and the babies, we do need him to come home. He is our only care provider who takes me to my doctor's appointments.
Well, and I'll let you go on and tell me everything you want, but let me just tell you this.
I'm so sorry, Your Honor.
No, but ma'am, understand it's not your responsibility. It just isn't. It's his responsibility. Plain, just full stop. All right, you could have scooted it over and give him all kinds of room. It wouldn't matter. He understands or should understand what the court's order is. Okay, so anything else you want to tell me?
I would just please ask the court if they could let him please come home. We truly need him there.
Okay, all right, thank you.
Thank you, Your Honor.
Ms. Lundy.
Your Honor, in late 2023, the defendant was charged with domestic violence by my office, naming Ms. Dennison as a victim at that time. I believe he was arraigned on December 26, 2023, and given a contact order. And pretrial hearing before this court, Your Honor, on January 8, 2024, Ms. Dennison appeared, requested the no contact order be lifted. That case was ultimately dismissed at the time of the final settlement conference in February of 2024. And we're back here again, new allegations of domestic violence. I'm very concerned for the victim's safety. I'm concerned that the obligation of the no contact order feels on her. Obviously, we can't control how she feels and how she thinks, but the court is familiar with domestic violence situations, domestic violence relationships, and the shifting of responsibility. So I'm asking the court maintain the no contact order.
What was the never mind. Go ahead, sir.
No, I was anticipating what the court was going to, I thought I was anticipating what the court was going to ask. I just would add that the allegation in the police report is that this is a single shove onto a couch, is the allegation of the domestic violence. So the underlying crime that is alleged is fairly minor as far as in terms of the range of domestic violence cases that this court sees. And so I think that should be taken into consideration as well.
Well, but counsel, there's also an allegation of destruction of her property, right? So it's that being the count two on the complaint. So it's not maybe as simplistic as one wants to believe. I guess I'm also a bit concerned with this previous. Yeah, well, I'm concerned about a number of things. I'm concerned about the fact that we had the previous case. I'm also concerned that there's a no contact order in place. And it's just, at least at this, just ignore it. I mean, and it doesn't work that way. I mean, the cold-hearted reality is maybe you ought to tell me why I shouldn't incarcerate the defendant. I don't know that I could trust him.
Your Honor, I mean, I think, given the nature of the contact and the fact that the complainant is here requesting, she came here specifically to request that the no contact order be lifted. I understand, Your Honor, it is what it is. We are the court, prosecutor, court staff witnessed what they saw. However, incarceration, I feel, does not suit the alleged crime. I feel it's, I can understand the court perhaps denying the motion, but incarceration at this time does not seems.
Yeah, but if somebody's not listening to the court, why would I just slap him on the hand and tell him to go forth and sin no more? I mean, this isn't a hard one to understand.
No, certainly not, Your Honor. I suppose we are asking for clemency at this time.
I did get into the meat and potatoes of the report, but for the court's information, the officers observed that the bed mattress was flipped over in the bedroom when they arrived, and they observed broken glass on the bedroom floor, and the information provided to the victim, to the police officers at that time was from old Christmas ornaments the defendant that had been destroyed. It says that Dennison had destroyed, but I think that may be a typo in the report.
Say that part to me again.
So the report reads that there was broken glass came from old Christmas ornaments that Dennison had destroyed. I think that may be a typo and may need to say Isom. I think that just may be a typo, but that is what the report reads. And I want to be candid to the court.
In that last case, one of the other issues here is, and Mr. Burdell, maybe you can explain to me, why would your client be under a different assumption of what no contact meant if he's been through this before?
This case is starting to shift from the original domestic violence allegation to something judges often view just as seriously: compliance with court orders. The judge isn't only focused on what allegedly happened between these two parties. He's now looking at whether the defendant can be trusted to follow the conditions of his release. What makes this especially significant is that this isn't the defendant's first encounter with a no-contact order involving the same complainant. From the court's perspective, prior experience removes a lot of the benefit of the doubt. The defense is arguing misunderstanding, but the judge appears to see a pattern that raises concerns about accountability. What do you think? Was this a genuine mistake made in a confusing courtroom environment? Or should someone who's been through the process before know exactly where the boundaries are?
I think, that he did explain himself that it was ignorance and,
well, it can't be ignorance. I mean, it almost points to a flagrant violation because he's been through the process before.
Judge.
Go ahead.
Judge, I believe, I think Mr. Isom has explained himself, and at this time I have nothing to add on as to what his motivation or what was inside his mind at the time.
On the last case, did he abide by the no contact on the last case? Or did we have problems?
So I wasn't involved in the last case, but Mr. Isom is assuring me that he did on the last case. He was never violated on the last case, which again was dismissed. It's not a case he was not convicted for. It was not the case he was convicted of.
I understand that. I guess I'm trying to figure out whether or not, because the issue for me is whether or not he's going to follow the court's order. And the court ordered something, and it wasn't that long ago that we ordered it, on the 25th of November. And
well, Your Honor, I have, my limited contact with Mr. Isom in our conversations. I am confident that he will abide by the orders. He is, he has assured me that there have been no contact prior to this, and he has abided by the no contact order. Outside of the court, there have been no calls, there's been no contact. He immediately moved in with his brother. He's 60 years old and then with his brother into an apartment, Judge. And I am confident, no matter what the court orders today, he will abide by the no contact order. Granted, this is a fairly new case. However, he has been other than the indiscretion this morning, he has been compliant with the court's orders on everything.
I need that. Is he working?
Remodel.
He does, he's remodeling as a contractor. Are you a self-employed or do you work for somebody? He's self-employed. And do you have any big jobs coming up?
Lundy, was there something else you wanted to say?
To give additional context to the question the court had about the last time I counted, and from December 26th to the request on January 8th, the defendant would have been on a no contact order for 13 days. And he would have been out of custody. So there's not a lot of time in there for us to know. And now we're here and it's been, gosh, not very long at all, 7 days since the incident, the arraignment rather, excuse me. So, and if people again would contend that this is a bond request.
Did you provide the address that you're staying at to the court? Why not? You know what?
I don't know. I told my brother to get it. House is nowhere near there.
So, sir,
Yes.
your release order indicates, reading from paragraph 10, you're not to go to the 5229 West Michigan Avenue. And I'll leave out the lot number except with a civil standby with the police. Then it further reads, if this is your home address, which it is, you must find another place to live and notify court of your new address within 24 hours of your release from jail by contacting, and then we put the court's number in. What?
Jerry, he would be able to provide his brother's address today if given a few moments to make the call and just to confirm. You know, this is the first pre-trial. Just for the.
I understand it's the first pretrial, but I mean, I've got at least 2 violations before we've had the first pretrial. I mean, what is it? He doesn't think he has to follow the rule?
No, Judge, that's certainly not it. I mean, this is, you know, I mean, understand with the holidays that just occurred. It is a lot going on for a civilian. So, but I've assured him now that he has counsel. Like I said, I was just very recently appointed. I will make sure to give him extra attention to guide him to make sure that he is in compliance going forward.
When were you released from jail?
One day. Or
The 25th. And when did you go to your brother's house? What?
I went there then.
And so on the 26th and 27th, you didn't think you had to notify the court?
I didn't understand that part.
At this point, the defendant is facing trouble on 2 separate fronts. First, the alleged violation of the no-contact order by sitting next to the complainant in court. Second, the failure to notify the court of his new address after release, which was a condition of his bond. In criminal cases, bond conditions are not suggestions. They are court orders. Judges rely on those conditions to monitor defendants and protect alleged victims while a case is pending. What's interesting here is that the complainant is actively asking for contact restrictions to be lifted, yet the court's responsibility extends beyond the wishes of either party. Domestic violence courts often take a cautious approach because emotions, reconciliation, and safety concerns can change quickly. The big question now is whether the judge believes these violations justify jail time or whether stricter supervision would be enough.
I didn't read it.
Well, you better, I'll tell you what, I'll pass the matter. You just got to go find that address.
Your Honor, I believe we are requesting permission to approach.
Yes.
Our chair there.
You're scary. Mr. Allen. All right, we're record to reflect we had a pre-defense conference in this case.
My apologies, as I was speaking to your client.
No, that's fine.
So at this time, Your Honor, thank you for the bench conference. I did discuss the matter with my client. I do have two requests at this time. The first is that we, and understanding the bench conference conversation we had, first request is that it's my understanding that there's a final conference before Your Honor this Friday, rather than the adjourned pretrial on the 16th. We are asking that this be set for final conference this Friday due to the extended delay. The next one, I believe, won't be until February. My second request is that he be that the bond be that the PR bond be continued and that the no contact order, no go to be lifted. However, in lieu of that, we would request that he be not remanded and perhaps released on GPS house arrest. Heather, I can provide the address to your staff for that if necessary. But we are requesting that be that is obviously not our first choice for the GPS tether. Thank you.
Your Honor, as to those requests, if I may respond.
Yes.
The people would be opposed to setting this for final settlement conference this coming week, although this incident is from over the summer. The defendant was just arraigned last week, and the people would request additional time to be prepared to move forward to final settlement. As to the continuation of the PR bond, the people do continue their request for a remand due to the bond violation. Both observed here in court today, where the defendant came and sat down next to the victim in a very non-crowded courtroom where there were many other seats available, as well as failing to notify the court of his new address within 24 hours of his release.
Or I sentence him on the violations. Anything else you want to say, sir?
Not at this time, Judge.
All right. I'm going to find you in violation of those two things for the no contact and also for the failure to tell us your address, sir. And what makes this different, as I stress to counsel, and I've stressed here, is that this defendant has been through this before. He knows what the rules are. He knows what's supposed to happen. He was apprised in his previous case, he would have been apprised by the magistrate of the no contact. In this case, he's also apprised by the magistrate of the no contact. I think what makes this even a little bit more disturbing, and what I had indicated to counsel, was the notes from the magistrate signaled to court that at the time of your arraignment, there was a particular mention that the parties had been residing together since the incident, and that was made known to the court because of the intervening time frame. However, what that tells me is that it was more emphasized that there was a no contact, because I can tell that because the magistrate wrote it in her writing in the file that that's specifically what she's ordering. So that I'm clear in that regard, there was going to be this significant change in what was happening. It wasn't like something happened and then you're arraigned and going to do that. That was brought up. That's outside of the fact that then defendant is specifically told he cannot have contact. Specifically told that. And so the fact that he's been through it, the fact that that was raised at exam, he then comes in here and completely goes the opposite way and then sits down there. I can't ignore that. I think the other thing that is a bit troubling for the court, and part of the reason we tell you, you have to give us a new address, is to make sure that you're where you're supposed to be, or more specifically, not someplace you're not supposed to be. We don't have that either. So what I'm going to do here is that the defendant will be placed upon a GPS tether upon release. I'm not going to make it home confinement, but I am going to sentence him to jail. I'm going to sentence you to 5 days in the Washtenaw County Jail for the violations. On your release, you'll be released on a PR with a GPS tether prior to release. Defendant is remanded.
Does the court deny the request to change the no contact to a no non-consensual contact?
I am also denying that